The reading of my grandfather's will was scheduled for 2 o'clock on a Tuesday afternoon, in a conference room on the 14th floor of Hartwell and Associates, the firm where I had worked for the past 6 years. I knew the room well. I had sat in that same chair dozens of times, across from grieving families, nervous beneficiaries, and occasionally, people who believed they were about to receive something that was never meant for them. I knew the mahogany table, the way the afternoon light came through the west-facing windows, the faint smell of leather and old paper that never quite left the room, no matter how many times the cleaning crew came through. What I had never done was sit on the other side of the table as a beneficiary myself. That was new. That was today. My Uncle Richard arrived 11 minutes late, which was exactly like him. He came in with my cousin Derek trailing behind him, both of them wearing the kind of quiet confidence that men wear when they believe a room already belongs to them. Richard was my grandfather's younger brother by 8 years. He had spent most of his adult life orbiting my grandfather's success without ever producing much of his own, always nearby, always helpful in visible ways, always positioning himself at family dinners and holiday gatherings as the loyal one, the devoted one, the one who truly understood what the family stood for. He kissed my grandmother's cheek when he sat down. He squeezed my mother's hand. He looked at me and gave me a small, practiced smile that didn't reach his eyes. I smiled back. Mine didn't reach my eyes either, but for entirely different reasons. Before I tell you what happened in that room, and what Richard did not know about me, about my grandfather, and about the document he was so confident would go his way, drop a comment and tell me where you're watching from right now. I want to know how far this story travels. Because what happened next still doesn't feel real, even though I was the one who planned every second of it. My name is Claire, and I am 31 years old. To my family, I am the quiet one. The one who became a lawyer instead of something interesting, who lives alone, who doesn't post on social media, who shows up to Christmas with a bottle of wine and leaves early. To the clients I represent, and the courts I practice in, I am an estate attorney specializing in probate litigation. I spend my professional life inside the machinery of inheritance, the wills, the trusts, the transfer documents, the disputes that erupt when someone dies and leaves behind more questions than answers. I know exactly how these things work. I know exactly how they break. And I know, better than almost anyone, what it looks like when someone has tampered with one. My grandfather, Harold, was not a complicated man. He built a regional logistics company from a single truck and a route between 2 cities in Ohio. And over 50 years he turned it into something worth considerably more than anyone outside the family understood. He was methodical, private, and deeply fair. He believed that the people who worked hard deserved what they earned, and the people who didn't had no right to expect otherwise. He told me that when I was 12 years old, sitting on his back porch while he shelled peas, and I had never forgotten it because it was the clearest thing any adult had ever said to me. He also told me something else, 4 years ago. When he first started slowing down, he called me into his study on a Sunday afternoon, closed the door, and told me he needed my help with something important. He needed to make sure that what he had built went to the right people. Not because he didn't trust his family, he said, but because he had watched enough of his friends' estates get picked apart by the wrong hands to know that trust alone wasn't architecture. He needed the structure to be sound. So I helped him build it. I drafted the document myself. I walked him through every clause, every contingency, every condition. He reviewed it line by line, asked questions that told me he understood exactly what he was signing, and when it was done, we had it executed in front of 2 independent witnesses and a notary, and I filed the original with the probate court in our county that same week. Not with my firm. Not somewhere Richard could reach. With the court. Officially. On record. My grandfather passed away 11 weeks ago. He was 81 years old, and he went quietly. The way he had done most things. The family gathered, grieved, and then, almost immediately, began to orbit the question that families always orbit after a death. What did he leave, and who does it go to? Richard moved fast. Faster than I expected, which in retrospect I should have anticipated, because people who have been planning something rarely wait long once the moment arrives. Within 2 weeks of my grandfather's passing, Richard had produced a document. He brought it to my mother first, framing it gently, the way he framed everything, as something Harold had always intended but simply hadn't gotten around to discussing openly. The document named Richard as the primary trustee and primary beneficiary of the bulk of the estate, with smaller portions allocated to my grandmother for living expenses, and a modest sum to my mother described as a token of Harold's appreciation for her years of support. My name did not appear anywhere. My mother called me crying. She said she didn't understand. She said Richard had shown her the signature, and it looked like Harold's, and maybe this was what he had always wanted, and who were they to question it? I listened. I told her everything was going to be fine. I told her not to sign anything, not to agree to anything, and not to let Richard remove a single item from my grandfather's house until after the formal reading. Then I hung up and sat very still in my apartment for about 4 minutes. Then I opened my laptop and started working. The conference room was full by the time the reading officially began. My grandmother sat at the head of the table because that was where she belonged. My mother sat beside her. 2 of my grandfather's former business partners had been named in the original document and were present with their own counsel. I sat across from Richard, my hands folded on the table, a glass of water in front of me, my expression precisely neutral. The attorney conducting the reading, a man named Garrison, who had been retained by Richard, cleared his throat and began. He introduced the document. He described it as the last will and testament of Harold James Whitmore, executed 14 months prior. He began to read. I listened to every word. I had already read it, of course. Richard had submitted a copy to my firm as a courtesy, which told me he was either confident or careless, and I had spent 3 evenings going through it clause by clause with the kind of attention I usually reserved for opposing counsel's most aggressive filings. The language was competent. The formatting was correct. The signature looked, on its surface, like Harold's. Whoever had prepared this had done their homework. They had just made one significant mistake, which I would get to in a moment. Richard was watching me. I could feel it without looking at him directly. He was waiting for the reaction. The moment I registered that I had been erased, the flinch, the sharp intake of breath, the scramble for composure, that would tell him he had won before anyone had asked a question. I had seen that look before on other people in other rooms. It was the look of someone who believed that the document in front of them was the only document that existed. When Garrison finished reading, he set the papers down and asked if there were any initial questions before proceeding to the formal certification process. I said, yes, actually. There was one thing I wanted to clarify. Richard's expression shifted. Not dramatically. Just a small tightening around the eyes. The kind of adjustment someone makes when a room doesn't behave the way they expected. I reached into the folder I had placed on the table when I arrived and removed a single document. I slid it across the table toward Garrison, not toward Richard, toward the neutral party. I asked Garrison to look at the filing date on the document in front of him, and then to look at the filing date on what I had just handed him. Garrison looked. He was a decent attorney and a careful man, and I watched him understand what he was looking at in real time, the way understanding moves across a person's face when the ground shifts under them. The document Richard had submitted bore a preparation date of 14 months ago, just as he had claimed. The document I had handed Garrison was the original will, filed with the county probate court 4 years ago, bearing my grandfather's signature. 2 witness signatures, a notarial seal, and an official court stamp with a date that preceded Richard's version by 34 months. Under Ohio law, when 2 testamentary documents exist, the later dated document controls, provided it was validly executed. Richard's document was dated more recently. That was the part he had gotten right. But validity of execution requires more than a signature. It requires witnesses who can be located and questioned. It requires a notarial acknowledgement that holds up to scrutiny. And it requires that the testator, at the time of signing, be of sound mind and acting without undue influence. My grandfather had been diagnosed with early-stage vascular dementia 8 months before Richard's document was supposedly signed. I had the medical records. I also had something else. When my grandfather and I had executed the original document 4 years ago, I had done something that I do for all my high-stakes clients, something that goes beyond standard practice but that I had learned through hard experience was worth the extra step. I had recorded the signing session on video, with my grandfather's full knowledge and consent, showing him responding to my questions clearly and coherently, confirming his understanding of every major provision, identifying the witnesses, acknowledging the notary. 37 minutes of footage that established, without any room for argument, that Harold James Whitmore had known exactly what he was doing. Richard's document had no such record. Richard's witnesses, when I had quietly reached out to them through a colleague the previous week, had been difficult to locate. One of them had a history that would make a credibility challenge straightforward. The notary stamp on Richard's version matched a notary whose commission had lapsed before the supposed signing date. I had found all of this in 3 evenings. I looked at Richard then, not with anger, because anger was not what I felt. What I felt was much quieter, much older, the feeling of a person who has been doing this long enough to recognize the moment when the arithmetic becomes undeniable. I felt the same thing I feel when I'm sitting across from a fraudulent executor, and the last piece of evidence is on the table, and there is nothing left to argue. Richard's face had gone still. The performed ease was gone. He looked the way people always look in that moment, not outraged, not defiant, just suddenly very aware of the distance between where they thought they were standing and where they actually were. The attorney I had brought, a colleague named Patricia who specialized in probate fraud, leaned forward and spoke for the first time. She addressed Garrison directly. She told him that we would be filing a formal challenge to the submitted document on 3 grounds. lack of valid execution, testator incapacity, and undue influence. She told him that the county court had already been notified and that a hold had been placed on any transfers from the estate pending resolution of the challenge. She placed her own folder on the table. It was thick. Then she mentioned, quietly but clearly, that we had also referred the matter to the state bar, since the preparation of a fraudulent testamentary document by someone with a law license would be a matter of professional conduct, and that we had been in contact with the county prosecutor's office, since the submission of a forged instrument in a probate proceeding was, under Ohio law, a felony. Derek, who had been silent the entire time, pushed his chair back slightly, the way a person moves when they want to create distance from something without appearing to flee. Richard looked at me. For the first time in that room, he looked at me directly. Without the practiced warmth. Without the performance of family feeling. He looked at me the way people look, when they realize they have fundamentally misunderstood who they were dealing with. He said my name. He said it the way he used to say it when I was a child, with that particular texture of dismissal that adults use on the children they have already decided are not worth the full weight of their attention. I picked up my glass of water and took a slow sip. I told him I was sorry he felt that way. Garrison called a recess. The room reorganized itself in the way that rooms do when the structure of power inside them has suddenly changed. My grandmother, who had been very still throughout the reading, reached across the table and put her hand over my mother's. My mother was crying quietly. One of my grandfather's former business partners, a man named Gerald who had known Harold for 40 years, looked at me with an expression I couldn't quite categorize and then nodded once, a small, deliberate nod, the kind that means something without saying it. Richard asked to speak with me privately. He followed me into the hallway outside the conference room, and when the door closed behind us, the performance dropped entirely. He was not cruel in the hallway. He was something worse. He was desperate, and desperation in a person who has spent decades believing themselves untouchable has a particular quality, a kind of raw, disoriented energy, like watching someone try to operate in a room where the floor has just become the ceiling. He told me this wasn't what I thought it was. He told me Harold had spoken to him about his intentions, that the formal document didn't capture what Harold had really wanted, that the family needed to come together, that we could handle this privately, that there was no reason to involve prosecutors or the bar. He used the word family 4 times in 90 seconds. He said he had only been trying to protect everyone. I let him finish. Then I told him the following, because I believed he deserved to hear it said plainly, without softening, and without cruelty. I told him that my grandfather had sat with me in his study on a Sunday afternoon 4 years ago, and told me exactly what he wanted. I told him that I had spent 6 hours drafting a document that reflected Harold's intentions precisely, and that Harold had reviewed every line and asked questions that showed he understood what he was authorizing. I told him that the document Richard had submitted bore a signature that a forensic document examiner I had consulted 2 weeks ago had identified as having several characteristics inconsistent with Harold's authentic signature, samples, and that the examiner's report was part of the filing Patricia had placed on the table. I told him that the notary whose stamp appeared on his document had confirmed, in writing, that she had no record of notarizing any document for Harold Whitmore, because her commission had already expired. I told him I had not done any of this to punish him. I had done it because my grandfather asked me to make sure the structure was sound, and I had made a promise, and I kept my promises. Richard stared at me. He had the look of a man who had been moving through a room he believed was empty, and had just walked into a wall he hadn't known was there. He asked me what was going to happen now. I told him that was no longer a question I could help him with, and that he should call his attorney. Then I walked back into the conference room and closed the door. The formal challenge took 4 months to resolve, which is actually quite fast for probate litigation, a fact that reflects both the strength of the evidence and the decision Richard ultimately made to stop contesting and accept the terms of a negotiated resolution before the criminal referral went further. The estate passed according to my grandfather's original document. My grandmother was provided for. My mother received what Harold had intended for her to receive, which was not a token, but a meaningful portion, because Harold had loved his daughter and had said so clearly in writing. The business partners were honored as specified. Several charitable organizations my grandfather had supported for decades received their designated gifts. I received what my grandfather had left for me, which I will not detail here because it is private. What I will say is that the morning the transfer was finalized, I sat in my apartment with a cup of coffee and thought about a Sunday afternoon on a back porch and a man shelling peas, and the clearest thing any adult had ever said to me: the people who work hard deserve what they earn. My uncle Richard resigned from the board of 2 organizations he had served on. The bar investigation is ongoing. He has not contacted me since the hallway outside the conference room, which is an outcome I had anticipated and one I find appropriate. My mother called me the night the estate was settled. She asked me how I had known. How I had known to file the original with the court, to keep the video recording, to have the notary's commission dates verified, to move as quickly as I had when she called me crying. I told her that I hadn't known. Not for certain. But I had built the document the way I built every document for clients I genuinely cared about, assuming that someday someone might try to undo it, and making sure that if they did, they would find it was not undoable. She asked me why I hadn't told her any of this was happening, why I had let her worry for 4 months without explaining what I had. I thought about that for a moment. I told her that sometimes when you are carrying evidence, you carry it quietly. Because the moment you explain the trap, you give the other side time to build around it. She laughed, a little shakily. She said she didn't understand how I lived this way, moving through everything so carefully, always several steps ahead, always with the folder already assembled. I told her it was mostly just experience. You do this work long enough. You learn that the documents are never the whole story, but they are the part the story rests on. Build them right, and everything else holds. Build them wrong, and eventually, in a conference room with afternoon light coming through west-facing windows, the floor gives way. I deleted Richard's number from my phone that night. I did not block him with any particular emotion. I simply removed the contact, the way you close a file that has reached its final disposition. The work was done, the record was clear, the estate was settled. My grandfather built something from a single truck, and 50 years of intention, and it went to the people he meant it for. I think he would have found the whole proceeding very straightforward, actually. He had a word for situations where the right outcome eventually arrives, despite the interference of people who should have known better. He called it the math, working out. I poured the rest of my coffee down the sink, rinsed the cup, and went to bed. For the first time in 4 months, I slept without reviewing documents in my head. The silence was not empty. It was settled. And it was mine.